Okay, welcome back, ladies and gentlemen, also to the audience at home. We are going to continue the Congress of today, and we are doing a presentation, Walter and myself, both professors at the Erasmus University, about advanced rulings in customs matters, and we do a comparison between all kind of major customs jurisdictions and also some little customs jurisdictions. We also going to cover New Zealand because it's quite interesting there what they do in terms of asking fees for getting a ruling, which is different from all the other members of all the other countries that we are going to discuss. What are we going to do? If we look at the agenda on the next slide, and if you are sitting there, you are in. Yeah, there we go. The first thing that we are going to do is discuss a little bit of what we mean with a ruling, because I think that's essential if you make a comparison that we compare the same things, right? So we are going to discuss a little bit of what we understand is a ruling, and then also put that in a little bit of perspective about the changing relationship that we see between customs authorities on the one hand and market operators on the other hand. Not only in customs matters, but I think also more generally within tax matters, and how a ruling fits into that. Then we move to the second piece of the presentation, that is the take of the WTO on advanced rulings. And that lays the foundation to come to the comparison. And then we took a few countries, the UK, US, Australia, New Zealand, and we're also going to shed some light on what they have in South Korea. So a little trip around the world. That being said, let's go to the next slide. So we are going to discuss customs rulings, so rulings on customs matters. But I think it's essential that we then look at briefly what is a ruling. And a ruling is when a decision is made with somebody in authority. And it's really on a legal matter. So how do you interpret a legal provision in a certain set of facts and circumstances? That is what a ruling is all about. But if you put it in somewhat more perspective, then you can say that a ruling is a type of an arrangement. And an arrangement is a much broader term, right? And that is also, for instance, a agreement that you make with the authorities about which kind of documents you provide, the means of communications. It's not really that you make that a decision is made by the authorities about a legal matter, but it's more like a agreement, a practical agreement sometimes you can make with the customs authorities, whereas a ruling is more formalistic and is also open to appeal. But I think the differentiation between the two is important, because if we look to all the rulings that we are going to discuss by the countries, but also if we look to the proposals for binding valuation information, then it is limited to what we call ruling. Whereas in some member states of the EU, you currently see that you also can come to arrangement, so that the broader term, where you can, for instance, make arrangement about the means of communication, but also how you can account for transfer price adjustments and the like. So it's much broader than that. So that being said, now we know what kind of decisions we are going to look at. So the rulings, so the coming to decisions about legal matters by an authority, and that fits into a kind of a tendency, a trend you can say, where we shift from a more vertical relationship between the customs authorities and market operators on the other end. There's a tendency that we go to a more horizontal relationship, so a more enhanced relationship between authorities and market operators. We saw that already in other countries, but also in the EU already for some time with the establishment of AEO. You can have like a huge criticism of course on it, if it's giving the benefits that we expect from it, but still I think it's a trend and it fits into that tendency where we shift from a more vertical to a horizontal relationship. And if you then put that, look at rulings, I think that fits also into that tendency and the shift in a more reciprocal relationship between the customs authorities and traders. But then there is always that balancing act between the boundaries of the law, because a ruling should not go contrary to the legislation, obviously. It should be an interpretation of the legislation in a particular set of circumstances, but it cannot run contrary to what is in the legislation. But on the other hand, with a ruling, you will also want to obey the rights of the trader. So there's always a little bit of the balancing act between those two. So that is a little bit of a starting point of this presentation. If we then go to what is the WTO's take on advanced rulings, and it was already covered also in previous presentations, we see that the Trade Facilitation Agreement of the WTO lays actually the foundation to come to a ruling on origin and classification methods. That is obligatory for countries members of the WTO to implement that in their local customs legislation, and they encourage also to include in the legislation rulings on customs valuation matters. And that is something that is encouraged. It is not obligatory, but there's a strong encouragement. And if you then look at for what purposes you can come to a ruling on customs matters or customs valuation methods, it's about the appropriate method or criteria and an application thereof to be used for determining the customs value on a particular set of facts. So if we dive into a bit more detail about the benefits and then later on also the procedure, then we see that obviously a binding valuation ruling, why is it there? To give legal certainty. Now that's obvious, but it's also there to expedite the goods release, because if there are no disputes about the customs value, it's more easier to release the goods and not stop them at the border and have like audits and the like. So it is also a means of trade facilitation, you could say. And that we see, for instance, also in the Netherlands, where if traders can currently already come to a kind of practical arrangement, and if you come to a practical arrangement about how the customs valuation rules apply in a certain facts and circumstances, you are like asked to include a reference number in your import declaration, and that would mean that at the time of entrance of those goods, of that time of customs clearance, no questions will be asked about like the customs valuation position of those particular goods being imported. So this also that we see there, that it already works as a kind of a trade facilitation measure. If we then look at the procedure, so what is the WTO Trade Facilitation Agreement already saying about the procedure that should be put in place to come to a ruling? There are a few things that we have put here on slide. The market operator should provide all the information that's necessary. It's not laid down which kind of information should be provided, but of course all the information required. They leave it up to the members of the WTO to give more context about that. It should be issued within a specific period. Now, I think that is also relevant because otherwise you apply for it, and if you are granted a ruling within 10 years, that is not really convenient. So it should be a specific time period and not too long. The ruling is binding on the administration and may be binding on the applicant. Now, if we look at the European context, up until the Union Customs Code, it was always binding on the administration but not the applicant, but that changed with the introduction of the Union Customs Code in 2016. Ruling is valid for a specific period. Now, that is also what we see back in the EU. It's only valid for a specific period, but we will see for some other jurisdictions that it is that there is no specific period in place or a different period compared to the EU. And then only the holder of the ruling can rely on it. Now, Santiago explained it also in the European context by referring also to the Sony Supply Chain Solutions court case. So that is, at least in the EU, that is valid. And decisions are generally made public, but we will see that if we compare jurisdictions, that is not the case in every country. That being said, we are going to do a tour around the world, and we start off with the US. So what we did, we included certain tables, and in those tables we included 4 characteristics. The first one being the aim of what it is, very briefly, what is the purpose of that binding ruling in that particular country, the validity of that ruling, if there are fees involved, and then whether it is made public. And that we will do for a number of countries, except for South Korea, but Walter will shed some light on that. There we're not going to discuss these 4 criteria, but they have a special regime in place, which we want to discuss as well, because I think it's also interesting to shed some light on that in the context of the proposals that are pending at the EU, because they are like having a ruling system in place for the interplay between customs valuation and transfer pricing, which I find in particularly interested. The US. So the US, they have a system already for a long period where you can apply for a ruling at the Customs and Border Protection, CBP, and that ruling can be on various matters. And one of those matters will be the appraised value of the merchandise. And if you apply for that, in most cases that is a ruling that you will get from headquarters, so the HQ rulings. You can apply for that, and there's no a specific time period that they are valid. It's a period valid indefinitely, unless, of course, facts and circumstances changes. There are no fees involved, as I could not find any fees that are attached to applying for it. And what is interested, that is published in the Customs Bulletin and Decision, and most of them can also be found online in a system that they have online, the CROSS system, Customs Rulings Online Search System. And if we then look at how a ruling looks like, I've included one example on the next slide. That's very interested. Oh yeah, there it is. So what we see, and it is a little bit small, but of course slides will be made available afterwards, and then you can look at it yourself or go to the CROSS, the database. So you send a ruling request, and then you will get a letter back from the authorities. And in those, in that letter, you will have like all facts and circumstances that you disclose to the authorities. And then there is like some analysis in that decision and a conclusion. But so it is very comprehensive in a way. So everything is in there. Also, the name of the applicant is made public. And that is different from most other ruling systems that we see out there in the world, because then it is not disclosed the name of the applicant. But that is, for the HQ rulings in the US, different. There you see, I think it's even the name of the person that applied for it is in that particular ruling, and you can find it back. And what is in particular interested, because if you look, for instance, to BTIs or BOIs in the EU, it's also giving some facts and circumstances, but not everything, because they do not want to give away the name of the applicant. So some of the information is left out. But here, in the US context, everything is in there. So that is also quite interested for other market operators that find themselves in a similar position, to look at the database and to look at whether there are rulings granted to other importers under the certain the same facts and circumstances, to see, okay, how does the US customs authorities apply the custom valuation rules. And because it is made public, it is even interested for parties that are imported in other jurisdictions to take a look at the HQ rulings. And I think that is also often done by myself as well. If I want to know a little bit more about how customs authorities apply custom valuation rules in a particular set of circumstances, that I sometimes look at the HQ rulings, because they give quite some guidance, and sometimes guidance on particular elements where you do not find any guidance about in other jurisdictions, also not in the EU. So this is a very, very interesting one. If we look to another country, Australia, so they have also a ruling system in place. And there, you can have like a valuation advice. Those are also binding rulings on the valuation methodology, and also whether certain cost elements, price elements are dutable or not. So like cost elements like packaging costs, royalties, license fees, and the like. If you apply for such a ruling, it's valid for 5 years. There are no fees involved. And what is interesting here is that in generally, the rulings are not made public due to the confidentiality and commercially sensitive nature of the information by the applicants, which I can, for a certain extent, understand. But on the other hand, it is contrary to what is included in the WTO Trade Facilitation Agreement, where they encourage members of the WTO to make those rulings public. So this is also difficult for operators in or importers in Australia to compare how the authorities applied the customs valuation rules in similar situations, because they are not in the position to compare what the customs authorities did in a particular set of circumstances, because it's not made public. Although the customs authorities, of course, can look at all the rulings that are out there. They have also a special document, registration form, just showing it because I think it's interesting also from an EU perspective. I'm very keen on learning what eventually will be in the registration form. So we know how a request for BTI or BOI looks like, and which kind of data fields you need to fill out. But I'm also surprised to see how that will work for a binding valuation ruling, which kind of data fields you need to disclose to customs, which documents you need to attach. Now, and here, for instance, there's an example of Australia where you find which kind of data fields you need to include. So let's see how that would look like in a few years from now in the EU. Let's move to New Zealand. So, New Zealand, we call this presentation comparison between major customs jurisdictions. Maybe we should have put major between brackets, but I still included this one because the interesting part here is not so much where you can obtain a ruling for, because that is quite similar as what we saw in Australia. Now, the validity is 3 years instead of 5 years, but the interesting part here is that they ask fees for getting a ruling. Which is not the case in the US, not in Australia. Also for BTIs and BOIs in the EU, that's also not the case. But in New Zealand, they ask fees for requesting a ruling. Before we are going to look to that fee scheme, I've included some information about that on the next slide. Just wanted to say here that it's here different from Australia. Here it is made public unless, so it is the other way around actually. But here the information is made public in principle. So let's take a look at the ruling cost. So there's a kind of a build-up between in terms of the ruling cost. So there's an initial application fee of $300, including GST. And an invoice is issued on completion of the ruling, which covers both. Now, there it goes. The time spent by customs processing the ruling at an hourly rate in excess of 2.5 hours. And I hope they spend more than 2.5 hours. At least I think they need that, more than 2.5 hours to access all the facts and circumstances in a particular case. And any reasonable expense incurred during the processing of the ruling. I do not know whether that also includes travel expenses and the like, but I found this one also quite interesting. But if we look to the countries that we compared, it was the only one that really charges cost, and it was quite explicit of how the cost build-up looks like. So this is an interesting one. Not that I want to encourage to the EU to also include this, but just like in terms of this conference, I found it interesting to also mention this. That being said, then I move to you, Walter.
Yeah, thank you, Martijn. We continue the comparison between major jurisdictions with the United Kingdom. And what is it about? It's about certainty of how goods are treated on import and how much duty is levied, and the validity is 3 years. No fees, and as far as we know now, probably there will be no public disclosure of the advanced valuation rulings, as they are called in the UK, AVR. But I think what is interesting now, and I would like to focus a bit more on that now, is of course, okay, we have a binding valuation ruling, and we are also going to introduce it in the EU, but what is it about? On what kind of issues are we going to issue rulings? Are the customs authorities giving rulings to importers? Because customs valuation issues can be very complex issues, of complex facts and circumstances. And for me, at least, it's sometimes difficult to see how you can give a ruling to such a thing without it being too overcomplicated. And if we look now at the example of the UK, there it is very specifically mentioned that you can apply for an advanced valuation ruling, but only to establish the correct valuation method for a specific transaction. So only whether you can apply transaction value, and if that doesn't apply, can you then apply transaction value of identical goods, etc., etc. So that is actually what they do. And we saw, maybe if you looked at the slide Martijn presented a few minutes ago on Australia, for example, there you can also have a valuation ruling on the fact whether or not a royalty, for example, is included in the customs value. And that seems to be in the UK not possible. Because a royalty is something that needs to be added to the transaction value, but it doesn't in principle say something about the correct valuation method in terms of transaction value, etc., etc. So what I'm trying to say is, if you look at the UK, it's very limited in terms of scope of valuation rulings that can be applied for. One interesting thing, though, and that also has to do with some developments in the UK. They left the EU, but I think to a certain extent the influence of EU customs legislation is still there. And I think as a result of the Hamamatsu case, which was actually there before they actually left the EU, where of course it was decided by the court that customs value based on transfer pricing cannot be used as a transaction value, and then we have a lot of discussion whether it can be applied anyway. Yes, some customs authorities say it, but if you have adjustments at year end, then the question is, can we apply those adjustments, or should we just accept the customs value as it is? Well, in the UK they said, okay, if the transfer price is based on a profit split or a TNMM methodology, we do not accept that the transfer price is being accepted as a transaction value. You have to go to another methodology. So it seems to me that this would be a particular set of circumstances and facts that could be the subject of a advanced valuation ruling in the UK. And then going on, Martijn already said something about it. South Korea as the last jurisdiction that we would like to discuss. There you see that they have a valuation arrangement or agreement that is specifically introduced for TB methodologies. So what it discusses is, okay, is the transfer price that you use acceptable for customs valuation purposes? And can you take transfer pricing adjustments into account? In the EU, of course, we have a big debate as a result of Hamamatsu. But here they have solved it to a certain extent by using the customs valuation ruling. And what they say is, okay, you can apply the adjustment, the TP adjustment, also for customs purposes, if you have documentation drafted before the goods have been imported. That's, by the way, also a condition you sometimes see in the EU being used by customs authorities. And it's also demanded that the aim of the price adjustment is to ensure the arm's length nature. And you need to do an actual payment or refund. And then, if that is all the case, then you can make your TP methodology the subject of a customs valuation ruling. And that means that, if you do that, you can avoid all kinds of arguments with the customs authorities. And as I understand, you don't want to have an argument with the South Korean customs authorities. Okay, so yeah, that was the last slide. So I think, yeah, one of the big questions I think for the EU is what will be the scope of the binding valuation information in the future. And at this moment, there's not much being said about that, but I think that it will be crucial because, yeah, if it's only the methodology, then of course the scope is, limited, I would say. But if it's more than that, it will be interesting, but also very difficult, given the fact also that in the EU we work with 27 customs authorities. If you look, for example, to the US, and Martijn showed an example of a US ruling, there they discuss very complicated sets of facts, and they issue rulings for that. But there they, of course, have a central customs authorities, while we have 27 customs authorities. So that, I think, makes it very difficult to also make very complicated supply chains valuation questions the subject of a customs valuation ruling. But we will see, of course, what will be the real scope in the near future. Thank you very much for your attention. Are there any questions?
Hello.
Hello.
Very interesting presentation. I think the US model should be a clear goal to try to emulate. In the US, they also publish the Customs Valuation Encyclopedia, where they collect all the interpretations from customs and from the courts. And this takes me to a very relevant point that you made, which is advanced rulings or binding information is not only relevant in respect of the person who makes the application, it is relevant for all traders to learn what is the view of customs in order to comply correctly. What can I expect customs to do? And that will reduce conflicts, will reduce appeals at the courts and so on. So I think it's much cheaper to invest in advanced rulings than to ignore advanced rulings or have limited scope advanced rulings, and then you have the problems at the courts. The courts are much more expensive. So I think it's a worthwhile investment to have a good system of advanced rulings. And I didn't know about the South Korean experience, and I think as you said, taking into account the Hamamatsu case, it would be very, very positive for the European Union to have this set up. The problem, of course, is that in Europe, direct taxation is not a European tax, it's national, so it would be difficult to have that arrangement, but it would be, I mean, it's really superior to what we have if we were able to have something like the South Korea model.
Thank you.
Yeah, that was actually what I wanted to comment, but you said it already yourself indeed. So I think that ruling system will mean that we have a kind of a level playing field, which is necessary because we are dealing, as Walter also said, with 27 different customs authorities. So the question also is it the national customs authority that should be the one that is granting that license even, or that ruling, or should it be maybe an EU authority? Now let's hear out from our German colleagues if they're going to discuss the establishment of the EU Customs Authority. And the second thing, indeed, it's very nice what they have in South Korea, where you have like tax customs authorities and market operators, but in the EU that will be difficult to come to a certain arrangement, because tax matters are like not dealt with on an EU level currently.
Yeah, but still, on the other hand, all the transfer pricing policies are, I would say, the same everywhere in the EU. So, yeah, from that perspective, there is no obstacle to do something like this.
Yeah, that is true. But with South Korea, you come also to an arrangement that applies for customs and for the tax authorities and the market operators. And then it becomes different. If you only come to arrangement how transfer pricing documents apply for custom valuation purposes, then indeed, then it should not really matter because all the TP documentations are like drafted according to the lines of the OECD. But if you want to have like a ruling that applies to tax matters, customs matters, and is binding to the market operator, then it's difficult.
Yeah, I agree. Then you need to be importing in the country where you are established and are paying corporate income tax. And there are companies which are established in one EU country and are importing in other countries. So then it becomes very difficult.
If I may, I would like to add the recent case law of the ECJ in direct taxation fiat cases expressly allowed competences of member states, different competencies in member states for direct taxation. So it has been stated by ECJ at the level, at the moment, direct taxation is is just partly harmonized, and transfer price is competence jurisdiction in the jurisdiction of the member states, and this is very hindrance to the harmonization and to sort of alignment between transfer pricing and customs valuation between related parties. This is.
Okay, thanks. Then we are going to change. Are there questions? There are 5, but are they new questions or from the? No, we could continue. Okay, thanks. We are going to shift. Yeah.
Okay. Fortunately, I'm not the one giving the presentation on e-commerce or anything electronic, because I would have failed. Good morning, everyone. And once again, thank you for taking part in this first seminar of the second edition of the Ecce project. My presentation, as well as Professor D'Angelo, will focus on sanction and infraction. During my section, I will attempt to sketch a broad framework on sanction in the EU, with a couple of considerations on CBAM and on the recent proposal for a new customs code, allowing Professor D'Angelo to make some specific consideration on sanction on undervaluation and potential development moving forward. It is unquestionable that the role of customs authorities has significantly changed in the last 50 years. We transitioned from a system based primarily on the protection of internal financial interest to a system which has its aim to the protection of EU in financial interest and the realization of the European single market. In this regard, the adoption of a uniform customs legislation has been paramount in achieving this goal. Only by taking a united approach in matters like origin, tariff, and value, we can hope to achieve this goal. However, this harmonization has been imperfect. And it's still incomplete. Some subjects remain in the exclusive competence of the member states. Among these subjects, there are the sanctioning system, which is still entirely dependent of the national legislation. This means there are 27 different sets of rules on sanctions, which are based on often substantially diverse national legislation, national policies, and most importantly, different legal cultures. This can lead to important difference in the nature of punishment, criminal versus administrative sanction, in the type of sanction, fines versus incarceration, which is a good example, and in some cases even the designation of the infraction of the customs law as a chargeable violation of such violation of the customs law. The consequence of this structure are different. First, it is obvious that this schizophrenic approach, we could say, could compromise the realization of the external projection of the internal market. It's not harmonized, so there are 27 different subjects that are free to regulate the sanction aspect of the custom law. Second, in contrast, in the direct contrast to Article 325 of the TFEU, this could lead to an encouragement of fraudulent practice. Third, there is a possible harm on the competitiveness of the European market. An external economic operator, based, for example, in the USA, could be not so inclined to do business in Europe because we have this fractioned framework. Finally, there is also a potential ramification for other parts of customs law that are already harmonized. For example, we can look at the authorized economic operator status, where compliance with customs legislation and the absence of major infringement are among the criteria that must be met to get said status. This implies that the economic operator based in a country whose customs law is primarily criminal in nature, customs violation, is criminal in nature, may face discrimination when contrasted to competitor based on countries where the sanction regime is non-criminal or the same infraction is not even a violation of customs law, punishable by administrative or criminal sanction. In other words, quoting former Commissioner Algrida Semeta, there is no point in a solid single set of rules if we do not also have a common approach to responding when they are broken. Aware of these challenges, the Commission has put up many recommendations, more or less effective throughout the years, to provide a unified face in penalizing matter, in violation. In this regard, we can recall, for example, the 1981 proposal on the exercise of the right of appeal in customs matter, or the 1998 proposal on administrative sanction harmonizer, and a more recent 2013 proposal. However, the first two proposals were not successful because there was a unanimity rule at the time. The last one is more, as I will say later in the presentation, a political matter. As a result, we must look at the Court of Justice case law. In this context, the Court of Justice has stated in several rulings that the introduction of specific criminalization case may also be contemplated among the effective and dissuasive tools that each member state has a duty to enforce. However, when exercising the punitive power, member states must adhere to broad legal norms that are part of the Union legal system. To be precise, every enforcement measure adopted by a member state to protect the financial interest in the European Union must adhere to the principles of effectiveness, proportionality, and it must be dissuasive. A penalty is effective when it is not written in such a way that it is practically impossible to enforce when the situation arises. The principle of effectiveness applies also to impose the same or a similar punishment between EU law violation and national law violation. Furthermore, a penalty is dissuasive when it prevents an individual from violating the goals and regulations established by community law. Anyone who violates the law must be afraid of the penalty. In this regard, it's important not only the type and the severity of the punishment, but also the possibility of the punishment. If the violation is of the customs law and it's not punishable, or it's punishable by administrative or criminal sanction, it's a very different situation. The concept of proportionality is the most important, or at least one of the most frequently invoked by the Court of Justice. We don't have time to go in depth about what proportionality means. However, for the sake of brevity, we can state that member states must employ means that, while allowing them to effectively achieve the objective pursued by their domestic law, cause the least possible detriment to the objective and principle laid out by the relevant European Union legislation. In other words, the severity of the penalty, while left to the discretion of each member state, must be regarded in relation of the harm done to the community financial interest. All of these principles are now included in Article 42 of the UCC, paragraph 1 to be more precise, which states that sanction must be effective, proportionate, and dissuasive. The clause, however, is not the equivalent to say that there are now an harmonized sanctioning system in the EU, mainly due to two reasons. On the one hand, it's a soft provision, soft obligation. The Article 42 does not impose to the state duty to sanction administrative or criminally some infringement. It's simple rule of principles. Secondly, sanction must follow strictly the principle of legality. Article 42 is not able to be applied directly national on the national ground, but it must have first a national provision containing the detailed sanction. In the last year, between 2013 and 2017, more or less, there was a lot of discussion about the possibility to introduce common sanctioning systems. I can remember right now the PIF directive, which is notable in this regard. However, I would like to point out your attention on a couple of provisions. First, I would like to focus on the CBAM. As I'm aware that most of you know, the CBAM is a recent measure introduced in 2023 by the EU, which have as its aim the imposition of an economic burden aimed at reducing carbon leakage. Once important, have completed a reporting obligation. Although the Commission is hesitant to recognize that this charge is a legitimate customs duty, there is no doubt that there is a strict connection between the customs code and the CBAM regulation, which is made quite evident by the frequent reference to the UCC in the CBAM regulation. Having said that, Article 16 of the Implementing Act imposes an actual punishment in regard of CBAM violation. In fact, it is specifically stated that such offences are penalized by a fine ranging from 10 to 50 euros per ton of undeclared emission. So we have a specific sanction, we don't have a general principle. Furthermore, some interesting progress are made in the recent proposal of new customs code. Article 254, it's an error on the slide, and it's 254. Not only contemplate a duty for the state to impose at least an administrative sanction, but it's also contemplate a measure of the sanction, a different type of measure, which is also graduated based on the intention of the importer. So the question is it possible right now a real harmonization of sanctioning systems? It depends. And the answer for me is no, but let's try to proceed step by step. We must differentiate between harmonization and coordination, which are two concepts that are most often unified in a single word. Harmonization, it means that we have a single set of rules, okay? And in my opinion, this is not possible regarding sanction. Especially criminal sanction, because it's a matter that is strictly connected to state sovereignty. To have a single sanctioning system, it means that the member state must renounce to a significant portion of sovereignty. And I don't think that this is a feasible a feasible solution, because states are notoriously very jealous of their sovereignty. Also, in criminal matter, regarding sanction, there is also always a key political component and a key cultural component, and not only a legal point of view. What I think is possible? It's possible a coordination in only in administrative sanction. Like I said with CBAM, which is a good demonstration how a simple sanction could be introduced at the European level. For criminal sanction, I don't think that even a coordination is possible, at least in the near future.
Is it correct? Is it correct? Okay, thank you. First, thank you, Federico. First, allow me to express, as coordinator of the entire program, to express many thanks to Santiago and Jorge for the hard works in the organization of this. As we may be aware, a transnational organization is proven to be very complex sometimes. Bureaucracy is not easy to accomplish with, but we succeeded in the end. So thank you, many thanks to Santiago and Jorge por el trabajo duro, hard work done. I would be very brief on my presentation. Federico gave us an overview of the sanctions with a sort of pessimistic view on the future, no possible harmonization in the future. I would focus on sanctions and remedies for undervaluation, and I would focus on this because, as you may know, undervaluation is an infringement of EU law. It's the most common infringement of EU law, EU customs law, I mean. And normally sanctions are associated with undervaluations made by trade operators. Let's start with a dive into the reality of customs valuation. We all know there are some criteria. There is the transactional value. There are secondary methods of valuation. But the reality is that customs value is a debatable notion. When discussing customs value, it is often difficult to identify precise value. There are often more plausible values to be attributed to the same goods imported. This is the reality. WTO and UCC tried to increase legal certainty by stating as a baseline method the transactional value, the price paid or to be paid. But in the end, we know it is most common for national customs authorities to dismiss transactional value and to make reference to the secondary methods. And to the secondary methods, it is undoubtable that the customs value is debatable notion. Now, we discussed before transnational TNN methods. It is debatable notion. And there are also other methods, yes, formally put in the hierarchical method, but we know that following Euro 2004, it is very easy for national customs administration to dismiss transactional values, to going down to the fallback method. And as we know, fallback method is, my friend Santiago said, it is not a method, but in my opinion it is. It is a method, but for sure it allows customs and it allows a great discretion to the customs administration. So this is a dive in reality of customs valuation, debatable notion. Let's focus on sanctions and penalties. I promise to be very brief, not boring you with a theoretical framework, but we all know sanction and penalties are punitive measures. What does it mean, punitive measures? They require negligence or intent. That's clear in the ECJ case law. That is clear in the legal doctrine. That is clear. Sanctions are punitive measures. And of course, we discussed it before with Valerian, strict liability is not allowed for sanctions. Strict liability is possible, is plainly possible. Let me be clear on this point. Strict liability is possible for duties. This is clear. The trade importer may be considered liable for duties if the trade importer doesn't know the correct origin, if the trade operator doesn't classify it correctly, doesn't put the correct value. But in my opinion, and it should be clear for everyone, it is not liable for sanction, for punishment for this, because sanction imply negligent intent, or at least negligence in reporting something. This should be clear. And so this is the main question of my presentation. When a plausible customs value has been declared, it might be said that intent or negligence does occur. It might be said when a plausible customs value has been declared. Of course, it is a rhetorical question. For the sake of my presentation, you know the answer I would give to this question is general theoretical questions. And at this point, perhaps some of my friends from Olaf may tell me, but how dare you can postulate sort of condone of sanction for undervaluation frauds? Don't you know that we are striving to fight against undervaluation frauds? There are huge valuation frauds, and undervaluation frauds are growing more and more. Yes, I know, and I'm quite aware of undervaluation frauds as very dangerous phenomenon for the EU budget, and of course, I am in favor of fight against and imposing sanction against fraudsters which undervalue the customs goods at the import. I think we do have the responsibility to draw a line, distinguish between undervaluation frauds and unintended undervaluation. Of course, there is no clear dividing line between these two notions, these two concepts, but this is our role. This is the role of the legal scholarship, legal doctrine, to reflect on this. And I think the task is not easy to accomplish, but I think we have to propose some criteria to distinguish between these two, because I do believe there are lots of fraudsters, but the vast majority of the trade operators are legitimate operators, try to operate in compliance with the law, with the customs law. And I do believe we have to propose criterion, and I personally do believe one of the criterion I would opt for is the good faith. Good faith as a general clause in customs law. We all know good faith is implied in each relationship between the trade operator and customs. It is the base. What is good faith? It is what a reasonable trade operator is expected to do in a reason in that circumstances. So good faith may be key concept, may be general clause, key concept in distinguishing between undervaluation frauds and unintended undervaluation. By the way, I'm in favor of punishment of undervaluation frauds with severe sanctions, much severe than than what is applied in certain countries, perhaps. I got confirmation of my opinion, good faith as a general criterion, as a general clause in customs law and for sanctioning customs law, by the new proposal, the proposal of a new customs code. We know the customs code contains a section devoted to sanctions, and one article in this section, Article 247, I put here, is expressly devoted to the general principle of sanctioning infringements of customs law. And in this article, the first paragraph of this article, and it is also very meaningful, the first paragraph of this article, it makes a reference to the good faith, stating that good faith is to be taken into account in determining sanctioning, shall be taken into account in determining the sanction. Well, let's switch briefly now to remedies for undervaluation. We heard a very insightful presentation on advanced rulings, but advanced rulings are not remedies for undervaluation. And in the UCC, there is a lack of a general remedy for undervaluation in the current UCC. I do believe this might be a weak point of customs union, because we do not have a general procedure, a general voluntary discovery of undervaluation done. Respect to the other customs area, for example, they do have general voluntary disclosure for undervaluation. The only provision tentatively applicable as a general remedy is Article 173, the UCC, paragraph 3, which allows for requests for amendments to the customs declaration. It is not clear how the National Customs Administration implemented this article, and particularly for my presentation, it is not clear whether sanction should be applicable in this case if the adjustment is an upward adjustment of the customs value. It is not clear if sanctions are applied entirely, mitigated, or they are not applied at all, and so on. Well, that's a weak point of the European Customs Union. So I proceeded to the conclusion. I advanced some ideas to be better explored. Of course, these ideas should be better explored, and our role is to elaborate on this proposal, not proposal very much, but ideas. First, good faith specified. We need guidance on good faith. In what condition good faith may be deemed to be in place? Of course, this guidance can come from ECJ, but it is quite difficult. I would assume that some European institution may release guidance on situation in which good faith is in place, is present, and so sanctions should be mitigated, or at least altogether pushed out. So this is the first idea. Second, a very pragmatic idea, perhaps not theoretically perfectly founded. Minor value adjustments, for example, we assume 5% adjustments may be considered not sanctionable altogether. This is a very pragmatic approach, theoretically not ideal, perhaps, because we legitimize sort of 5% de minimis mismatching, but it is a pragmatic measure. Of course, this is just an idea to be discussed. Third, voluntary disclosure. We may consider the introduction of voluntary disclosure scheme in the new customs code with mitigation of sanction, or perhaps not sanctionability altogether when the trade operators ask for an upward amendment to the already submitted declaration. These are just ideas, so we have to discover just ideas also for other seminars to be discussed. I stop here, and of course I thank you again, and I remain open to your questions and remarks to my presentation. Thank you so much.
Yeah, your statement was eventually also advanced ruling, but also the options that you gave are not necessarily a remedy to prevent undervaluation. But I think partly that is not true, in a way that if you would have like an advanced ruling, I think there will be less discussions about the value, because then you come to a understanding about which documentation is sufficient to substantiate the value that you're using, because especially if you are in situations where you use a very low value because of market penetration, or because you want to give a huge discount, or you have like stock of apparel products still which are out of season, then there are all kind of valid reasons to apply a low value. And if you then come to an advanced ruling where you arrange with the customs authorities, okay, but this value is appropriate in the given circumstances, then you free up resources also from the customs authorities to focus more on other transactions and let that market operator import the goods against that particular value. And I found your comment about voluntary disclosures very good, because I think that is really what is now lacking in customs legislation. We see for tax matters, we see voluntary disclosure schemes, but now even legitimate traders that makes an honest mistake, they are like hesitant to come forward, because if they come forward, it's a quite bureaucratic way to disclose your customs value. You are not really certain about the reaction of the customs authorities. There can be sincere penalties for only a small mistake, and then even interest on top of it. Now we had that court case of the from the ECJ, where they confirmed that penalties, what was it, 50% of the customs debt, that was proportional. This would be welcomed, a proposal for a voluntary disclosure scheme, I think, because then also traders in good faith will come forward. Also there you will free up resources for the customs authorities to really focus on the bad guys, so to speak. So that that would be, I think, the way forward. And now is the momentum, because there are proposals now of the reform. There are no voluntary disclosure schemes in there yet, but I think that is something they should include now.
That is, of course, also because, and Federico discussed that, the whole criminal customs law, so to say, is national law. So that means that you can have a voluntary disclosure, but that would be under the national legislation. And what I would like to make a remark, Federico was talking about harmonization of customs penalties. And there you see a lot of differences, I think, between the member states. You mentioned the example of the 50% penalty. But yeah, I think in the Netherlands we would say some of the penalties which are applied in other member states we find draconic, so to say. And so it's also a cultural thing, I think. And even if you look at the proposals of the European Commission in the UCC reform, under certain circumstances they are suggesting penalties which are a percentage of the customs value. And even if there's no duty, if the duty rate is 0%, then you can have a penalty which is dependent on the customs value. That's of course, idiotic. So I think, there needs to be a more realistic approach to this kind of problems. Of course, there are fraudsters, but there are mistakes are easily made in customs. Everybody knows that. So you need to have a proportionate administrative penalty, maybe, but it should not be possible to have these draconic things. And in that sense, it's also important, indeed, what you mentioned. Under the current legislation, it is difficult to amend, for example, a customs declaration. If you, after some certain point of time, find out that you made a mistake, then it's sometimes very difficult to correct that mistake. And there should be much more possibilities in the legislation for that to allow bona fide traders to act on that.
Of course, totally agree. Martin, you are right. Diego.
Go ahead.
Totally agree. Advanced ruling may be remedies. For remedies, perhaps it is a linguistic. We consider from Latin linguistic point of view, ex post remedy when I submitted. But of course, I agree with you. Also, advanced ruling may be a very good tool to improve relationship, improve legal certainty in customs matters. As Walter said, in customs matters, errors do occur often. Customs legislation is very complex, so each tool is welcome in customs legislation.
Okay, just a comment. Regarding the level of penalties, I think if I were a fraudster and I decide, I'm going to commit fraud or not, of course I will take into account the level of penalties, but I also take into account how likely it is that I am discovered. And I am afraid that countries that apply high levels of penalties is because they acknowledge most of fraud gets away with it. And so we need to apply a huge punishment on the fraudsters we discover to be effective. So I think that the level of penalties gives you an indication how good is that customs administration. If a customs administration is not so good, you can expect higher penalties. If a customs administration is efficient and actually controls, you can expect lower penalties. Because with lower penalties, if I know the chances of being discovered are very high, okay, why would I risk paying a penalty? But if I think it's very unlikely they are going to discover me, even if they apply very high penalties, maybe I take the chance. So this is another point. So it's an indication of negative quality.
Sorry, can I just a second? I don't think so. I'm not so sure. Because if I remember correctly, when we were writing the book, I spoke with Benedict about sanction in Germany, and in Germany there is a threshold for criminal sanction of €1. Do you know, €1. In Italy, the threshold is much higher, and I think that level of control in Italy are less desirable, if we can say that, than Germany. So I think that surely there is a huge component of the problem of control that you said but there are also a huge component on the legal culture. If a state is more repressing, it's say that, for example, in Italy, there is always the choice to, okay, I don't want to go through a lengthy process, so I try to have a type of sanction that that you want to pay immediately and not go through process. So it's not only the controls phase, but also the remedy phase that influence the type of sanction, in my opinion. I don't know if it's clear.
Thank you. I wanted just to react to a remark of Professor De Witt when you said that in the UCC reform they are suggesting penalties that are percentages of value even if duty rates are 0%, and this is idiotic. Well, this is what I understood. I think that you said more or less this.
That's what I said.
Thank you. How would you relate this with the fact that the value of the customs duties is also used to determine the amount of VAT due? I mean, this is also an important component, and fraudsters very often are not focusing just to evade the customs duties that, as you know, is maximum around 10%. Okay, if there are no anti-dumping duties. Normally in textile shoes, for a lot of goods, actually, for most of goods imported into the European Union, customs duties are 0. But what is really interesting for a fraudster is rather evading VAT, that of course is also due at import.
Yeah, but that's in e-commerce, of course, always. For that kind of situation, you could use a percentage, of course, but then I think the legislation should make more clear that make a distinction between different situations. And I see it now, and also in older proposals, there was no distinction between different situations. And also with VAT, I think it's very important, because there are also situations where you see that legitimate businesses are attacked on customs valuation, and it has a result for import duties, but also for VAT, and they are able to deduct the VAT, of course, and then even then penalties are imposed on the VAT which was underpaid or underdeclared. That's also, I would say, disproportionate, because you can deduct the VAT, and you know the example of the UK versus the European Commission, where the Court of Justice said, okay, we are not going to, the UK does not have to pay the VAT because the traders would be able to deduct it. So I think there's, you cannot, have a standardized approach to this, because it's too complicated and too dependent on different situations.
If I may interact, I'm not so sure to remember that in the UK case, the Court of Justice said that the VAT is not relevant because it is possible to deduct it. Actually, I think that in the UK case there was a huge VAT loss that was double than the customs loss. The customs loss was calculated in 2.6 billion euros. The VAT loss, as a rule of thumb, was the double that went, but the issue there was that the VAT loss was for the UK budget, not for the European budget. But with an additional issue that was a huge problem, and there was a huge effect, also spillover effect on the internal market, because it negatively affected all the internal market, such a huge introduction of undervalued goods, textiles and shoes into the European Union, without thinking about the negative effect for European producers of these goods that, of course, most probably were not in the UK but in other member states.
We proceed to next. Any question? No? Okay. Okay. Next session.
You can see the presentation. Hello, everyone. I'd like to start by thanking Massimo Fabio and all the ECC project members for the invitation to be part of this seminar, and extend my compliments to everyone who join us in person and online. I'm delighted to be here today to discuss the role that arbitration can play in the customs field and to share the Portuguese experience in implementing a domestic tax arbitration regime. In my personal opinion, the analysis of this topic is part of a broader discussion on the arbitrability of disputes within the public administration in its tax or customs aspect. So we look to Portugal as an example on tax dispute resolution as a starting point for a discussion on the effectiveness of the different systems for resolving customs disputes in the EU. Let's see, yes. For better time management, I decided to focus my presentation on answering three main questions. First, why should we even consider the possibility of resorting to alternative means of dispute resolution in customs matters? Second, is arbitration a viable option in customs? And answering yes to those two questions, the third and last question concerns the practical and legal challenge of its adoption. So let's start with why. Many EU countries, such as Portugal, Spain, Poland, Italy, Lithuania, and Greece, just to name a few, do not have specialized courts to deal with complex customs cases. And one of the most challenging areas is, no doubt, customs valuation. The autonomy of the EU customs valuation rules, the proactivity of the European Commission and OLAF in controlling member states, especially in the context of undervaluation of goods, or just the fact that customs value must be determined on a case-by-case basis, place a specific burden on customs administration, and as a result, they often resort to internal database and a hardline approach to identify alleged undervaluation practice with high potential for litigation. And if we combine complexity and lack of specializations, cases submitted to judicial state courts can take up 3, 4, 5 years or longer, compromising legal certainty and predictability, as well as the ability of the economic operator to be competitive in a global market. So thus, there is a strong need for a more efficient, specialized, timely, and cost-effective customs dispute resolution mechanism, which leads us to the second question. Within this context, is arbitration a viable option in customs? Well, the idea of submitting disputes between tax or customs administration and economic operators to arbitration is not new, but it's still a bold one. This debate has been on the agenda of several countries such as Portugal, Spain, Cape Verde, and Brazil for more than 15 years. From a domestic perspective, however, tax arbitrations that decide on the merits of the claims are still not available except in Portugal. Tax arbitration was introduced into the Portuguese tax system in 2011 by way of a decree law to solve domestic tax disputes regardless of whether they involve domestic, EU, or international law, and regardless of whether the taxpayer is resident or non-resident in Portugal, and does not exclude, at least expressly, the competence of the arbitration tribunals to assess the legality of customs duties on importation, classified as taxes under the Portuguese law. However, this exclusion was later provided for in the ministerial order or binding regulation of the Portuguese Tax and Customs Authority, which we'll look at later. At the time it was excluded, it was due to an insufficient basis for the selection of arbitrators specialized in customs to ensure its proper functioning. Unfortunately, when Portugal joined the EU and the single market, customs law lost its practical relevance and was eventually removed from the academic programs. But with the reintroduction of customs law into the academic programs in the last decade, the extension of the scope of our arbitration tribunals on customs has once again been added to the agenda. And it's also worth noting that despite the exclusion, the Portuguese arbitration tribunals are already competent to hear domestic disputes regarding excise duties administered by the customs authorities in which the tariff classification of goods is at issue. In any case, although our current regime is not applicable to all customs disputes, in my opinion, arbitration can be an important tool in countries with long delays in customs procedure or with particularly complex cases which require greater specialization, such as customs valuation in transactions between related entities or the payment of cross-border royalties. As this topic is so wide, I'll focus on the main legal and practical challenges, the first of which has to do with the constitutional admissibility. In Portugal, the possibility of establishing arbitration tribunals is expressly provided for in the Constitution without any limitation as to the subject matter, which can provide a more favorable legal environment for arbitration. However, even in states where the Constitution does not expressly provide for the possibility of creating arbitration tribunal, as the case here in Spain, and in a context where traditional means do not seem to guarantee effective jurisdictional protection of the taxpayers' rights, at least for a lack of a better option, the failure to provide for alternative means of dispute resolution in tax and customs matters may be interpreted as an unconstitutionality by omission. This is why, because the speed of the procedure is now perceived as an essential requirement for ensuring the fundamental right to access courts and effective judicial protection of taxpayers' rights, induced trust, and the perception of legal security. There are key issues when it comes to international trade transactions. Well, once the main constitutional issue was settled, some legal questions remain. For example, the question whether the tax arbitration system was a form of privatization of justice and the alleged breach of the principle of the unavailability of the tax credit provided for in domestic tax legislation of several countries, including Portugal and Spain. And in Portugal, both of these issues were overcome in 2011. First, because the tax arbitration system emerged as an alternative dispute mechanism based on the Constitution and the authorization given by the Parliament. Then the legal regime lays down the jurisdiction, method of appointment, fees, and rules of procedure for arbitration tribunals, the effects of their decisions, and the available remedies against those judgments. Under this framework, the tribunal's decision must be carried out in accordance with established law, meaning that they are expressly prohibited from resorting to equity. And like judicial tax courts, the tax arbitration exercise judicial functions and must follow an inter partes procedure. It is also worth noting that an arbitral award has the same legal force as a judicial tax court decision. As a result, the recourse to arbitration, like the recourse to judicial courts, does not jeopardize the availability of the tax credit whose legality is challenged. Well, this brings me to my next point. The features of a customs arbitration regime must fit together like a puzzle to make it an attractive path for the economic operators without compromising its public credibility. And based on the experience, the preference for an institutionalized arbitration model ensures great predictability and uniformity of procedures. In Portugal, tax arbitration is organized under the Center for Administrative and Tax Arbitration, otherwise known as CAD, which is the center legally authorized to promote the resolution of disputes in tax matters. CAD is quite an original, not-for-profit association, self-financed through its own revenues and the arbitration fees paid by the losing party. The recourse for tax arbitration is also voluntary and depends on the taxpayer presenting a claim before CAD and the acceptance by the Portuguese Tax and Customs Authority, which was approved by a ministerial order expressly establishing the acceptance of tax arbitration regime and the extent to which the authority is bound to arbitration. So, according to this ministerial order, the Portuguese Tax and Customs Authority is pre-bound to the arbitration and cannot refuse to litigate in the arbitration tribunals or opt for the state courts. So, within the scope of the pre-binding of the Tax and Customs Authority, this option remains with the taxpayer only. At least in the startup phase, the Portuguese legislature also decided to narrow the material scope of the tribunals on the grounds of the case, but also on its value. Therefore, arbitration tribunals only have jurisdiction to rule on the claims for the declaration of the legality of tax assessments, provided they do not exceed 10 million euros. As I said before, there are certain acts that have been specified as being beyond the scope, such as some customs duties. And in my opinion, there is no good reason for this exclusion other than the difficulty of recruiting arbitrators specializing in those matters. In the legal design of any arbitration system, one of the most sensitive topics is indeed the selection and appointment of arbitrators. That's why, under the Portuguese regime, arbitrators are chosen through a public procedure from among people of proven technical ability, moral character, and sense of public interest, and must have a law degree with at least 10 years of proven professional experience in tax law. Or in matters requiring a specialized knowledge of other areas, a person with a degree in economics or management may also be appointed as an arbitrator, not presiding. The president of the tribunal, however, must always have a law degree and be a former tax judge or hold a PhD in tax law. Arbitrators are also subject to the principles of impartiality and independence, as well as to the duty of tax secrecy. And to meet this purpose, a specific set of rules, impediments, and conflict of interest is in force, imposing special duties on the arbitrators. Cost-wise, when arbitrators are appointed by the Ethics Committee, the cost of litigation is similar in both arbitral and judicial tax courts, which grants the generalized access to arbitration by all citizens. Another advantage of the regime is the speed of proceedings. Matters submitted to tax arbitration must be decided within 6 months, with a possibility of an extension which should not exceed a further 6 months period. And on average, tax arbitration decisions are issued within 5 months. And as a rule, the arbitral decisions are also final. In other words, not subject to appeal, thus allowing the parties to obtain a final decision far more quickly. However, this rule does not preclude the possibility of an appeal on constitutional and formal grounds, and whenever the arbitral award is in opposition with a decision issued by a higher tribunal. I believe that this compromise reflects a fair balance between celerity and legal certainty. Finally, in an EU member state, direct access to the ECJ is critical, especially within the framework of customs. And in 2014, when called upon to rule in the Ascendi case, the ECJ considered that the Portuguese tax arbitration tribunals fulfill all the requirements to be considered a court or a tribunal of a member state within the meaning of the EU treaty. And since then, they have submitted 39 requests for preliminary ruling. The direct access, in addition with the limitation on appeal, makes arbitration an attractive option if the taxpayer seeks a quick and final decision. And it also can be an excellent option for customs. To conclude my presentation, I believe that in Portugal, the arguments in favor of tax arbitration have prevailed due to several reasons which can be extended to customs disputes and in other countries. The speed and early publication of the award can have a significant preventive effect on the outbreak of litigation, allowing the economic operator to anticipate the cost, the tax and customs administration position, and adjust its behavior to avoid the cost or risk of litigation. Specialization is another major advantage of the regime in technical areas such as customs valuation. Also, transparency of proceedings and the publication of the award also show that the regime pays due respect to the principle of legality, ensures equality between taxpayers, and protects the rights of the parties involved. Another example of how arbitration can be highly positive is dealing with new issues, often just a few months after an assessment was issued. This fast pace allows both parties to correct or change course, fix procedures, and avoid years of litigation and achieve greater certainty. The regime also contributes to successfully reducing the length of the disputes, which is one of the major obstacles when doing business, especially, unfortunately, in Portugal. That brings me to the end of my presentation. If you have any comments or questions, I'll be happy to hear them. Thank you very much. And I'm sorry that the PowerPoint is not, the format is incorrect.
Okay. So, yeah. Ah. Can I start? Yes. Okay, thank you. So, good afternoon. My name is Diego Modonesi. I am head of sector in OLAF and the Customs and Trade Fraud. Thank you very much for the invitation also this year to this conference. I've prepared this presentation for you concerning these recent trends in national case law concerning undervaluation. Here my idea was also to summarize a bit what we discussed in the previous cycles of conferences, at least the one where I took part of, concerning undervaluation. So I will go through the main points of the background, the reasonable doubt, in particular the Court of Justice case Euro 2004, the fallback method, and my intention is to go through certain national case law, in particular in certain member states that focused and dealt with the fallback method. And finally, the certain topics or certain principles of the EU legislation, or in particular on the fallback method, and finally the conclusions. First of all, the background here, well, we know very well that in the past the customs value was based on the normal price to be charged, and so it was the normal price for a certain type of goods. The consequence was normally the uncertainty, because it was open for discussion. We are talking about a period of time, last century, of course, when the international transactions were not so many, or at least the international transactions outside the European Union. There were customs transactions among what today are member states. Now, with the European Union, we passed to a completely different system that is based on the transaction value. Well, it is irrelevant as a matter of principle that the price is lower than the current market price value for goods that are on the markets. But of course, here the risk is that fraudsters might be prone to declare an amount of a value, a certain value that of course is consistently lower than the real price. So what are the customs frauds that we can see, and how the fraud is happening in practice? Here I've identified the three main methodologies, and at least for the time being I don't deal necessarily with e-commerce, because the frauds are even a bit different from these typologies that I've identified. In simple EMTIC case, missing trader intra-community fraud cases, fraudsters sell the goods, charge the VAT to the buyers without remitting the value then to the tax authorities. and in other cases, the value is lower and the company is a phantom. So let's try to go one by one through these three different cases. Here I put as a pure example the names of, well, at least not actually even the names, but the image of certain member states, but it's just a matter of example. So the pure undervaluation is when the importer is importing goods, of course, undervalued into the European Union. Is relatively simple. To make things a bit more complicated, what is possible here is, at least in this slide, is that the customs broker is located in a different member state. So the goods can enter into a different member states, for instance in Belgium. They are declared by a customs broker and they are shipped under Customs Procedure 42 or with other mechanism of simplification in order to avoid the pay, or not to pay in a legitimate way the VAT to different countries, and then they are sold to the final buyers. The second case perhaps is a bit more even primitive, a bit more crude. We have also in this case, in this example, a customs broker, but then the goods end up to a missing importer. I call it missing importer, meaning an importer that operates for a certain number of months in a member state and then subsequently disappears. So this is also something that we have seen several times. Another mechanism is also linked to MTIC VAT. Here the system is becoming more complicated. There is a missing trader fraud that is complemented with an undervaluation. The fraudster is not a successful fraudster if he doesn't evade both customs and VAT. So this is their goal. What we have seen here, as you can see, we have an importer that is a phantom company or can be a legitimate company that then sells to a missing trader in a different member state. And very often the transportation, they find a way to have a transportation that perhaps doesn't even pass, in this case, for instance, through Belgium or through the member state of the customs broker. The goods should go physically in that member state. They sometimes simplify, they avoid even the transport in case of controls, or for instance, if it is a transit, they are able to present to the customs authorities goods on the immediately. But in case of no transport, the goods are not passing from that specific member state. And here, there is also another reflection that is important to make, is that, of course, in a chain of transactions, if the goods are entering undervalued into the European Union, but then are sold to the final consumer for the real price, and by a legitimate company, of course, there is no VAT fraud, because the VAT fraud takes place only at the very last moment of the chain of transactions. But what's the point for a fraudster to introduce goods for a price that is extremely undervalued or very much undervalued? Let's imagine 10% or 20% of the real price, if then you don't evade also the VAT. Here, the practical reality in this kind of cases is that the goods then they end up in the black market, or they manage to break the chain of transactions. They manage to impede, to prevent to the customs authorities or to the fiscal authorities the possibility to understand the price of the goods, and therefore to subsequently avoid not only the customs duties but also the VAT. So, okay, there is a bit of animation concerning. So I wanted to. This was the reassessment, of course, of the customs duties. So in the previous slide, we have seen what is the chain of possible undervalued frauds. But what are the tools to prove undervaluation? And here we had an interesting discussion last year with Professor Ibanez on Euro 2004 case. Of course, in this case, the European Court of Justice considered that there is a reasonable doubt, and that it's possible to prove the reasonable doubt the existence of average and median prices for the relevant databases. But the key point that was criticized last year here in Valencia by 2 years ago actually here in Valencia by Professor Ibanez was the fact that there was that the customs authorities had not accepted the data that were provided by the importer, by the indirect representative of the importer, in this case in Hungary, by this company, Euro 2004. Just a reminder, this company was importing goods at around 10% of the normal market price, and therefore customs authorities were particularly tough in trying to find arguments in order to prevent these goods to enter into the European Union. Just most probably the price declared, the value declared was less for these goods, I think that were textiles, but most probably was less than the value of the raw materials necessary to produce those goods. So there was a really clear undervaluation, and at that time in Hungary there was a major undervaluation fraud. So what happened here was that the customs authorities asked a certain number of documents to the importer. So, and all these documents were provided by the importer, meaning the invoice, the transport documents, the bank transfer, the fact that the bank transfer was properly registered in the accountancy system. Nevertheless, the customs authorities rejected the customs value. So, what else could have the importer do in such a situation? Why such a bad decision for the poor fraudster and for the lawyers who wanted to import goods for a value so low? What the customs authorities, what the importer could have provided if even the bank transfer was in line with the cost, with the value declared? Well, here there was not a specific request by the customs authorities to the importer, to fiscal representative. There was a discussion between the two companies. And here I'm going also to reply to a question that was made by Professor De Witte in Rotterdam around 1 year ago. What the importer or the indirect representative could have provided, and this would have killed the whole discussion, could have been, for instance, the foreign trade agreement. This was not provided. Or could have provided the business correspondence between importer and exporter. Or could have provided even the export customs declaration in China. If the export customs declaration in China was exactly the same of the import declaration to the European Union, and normally what we see, what we have seen in Olaf sometimes, there is a difference of 10 times between one and the other one. If they had provided one or perhaps even these three pieces of evidence, perhaps the Euro 2004 case would have never happened. So this is perhaps this is a bit the background of the case. So, well, in this slide, yeah, basically these are elements that I've already explained. And here leads me to the third point of the presentation, that is the fallback method. So the first stage is the reasonable doubts that allows the customs administration to discuss the customs value. The following step is to redetermine the value. So the value of transaction is not good because it's extremely undervalued. How I can redetermine this value? I can use different valuation methods. We have discussed before about some of these methods, of course, identical goods, similar goods, deductive method, so on and so forth, until when it's possible, if none of this method can be used, to use the fallback method. Why it is important, this fallback method? It's very important because very often for these undervalued declarations, heavily undervalued declarations, it is not possible to find similar goods, it's not possible to find identical goods, and also the deductive method can be not usable for practical reasons. So, what is the national case law about the fallback method? Before discussing this national case law, I wanted to first discuss about what are the challenges for the secondary method, not for the fallback method, the challenges for the National Customs Administration. Of course, the current legal framework of valuation method was drafted for conventional importers. So for importers who are dealing with who are real importers, who are not missing traders, who are not taking part on fraud schemes, and who are in good faith, for which there is no systematic undervaluations. Unfortunately, perhaps I'm a bit biased, but you know, for the work that I do in Olaf, we see a lot of frauds, and of course, it's also here always very important to remind that the fraudulent imports luckily is just a minimum part of the real imports. However, we have seen also major undervalued import hubs traveling from one member state to the other one. And so criminal groups who are moving from one side to the other one of the European Union to undervalue goods and to link then the frauds, create the frauds, linking also VAT frauds, missing trader frauds, as I've explained before. So we have to find a balance between these two opposite needs. I think this is also very important from an academic point of view for an open mind session and discussion like the one that we are having here. So certain member states believe that, so it's important to, I think, consider also the way how the customs authorities need to operate. This is also in the interest, I think, for the legitimate operators. So customs authorities believe and they have to face the fact that the secondary valuation methods objectively is very complex. Objectively, it is cumbersome, and we cannot simplify and say, okay, it's their problem, it's not problem of the fraudsters. It must be a problem also for the fraudsters. The third point here that I would like to make in this slide is that the secondary method of valuation, the purpose is to find the closest price to the real transaction. And here, unfortunately, for certain secondary methods, comparative elements, industry standards might not be suitable. And this is the case in particular for e-commerce and for B2C transactions. We know that e-commerce, of course, can take place in B2C transactions, on the basis of B2C transactions, but also on duty delivery paid that normally means that the import is put in place by a different subject, and then the goods are sold by the marketplace to the final consumer. But we have to consider these aspects. And when there is an H7 is basically a simplified declaration that is used, the data set does not allow for a sufficient identification of the nature of the goods. So how can you use secondary methods in this case? How can you use the comparative methods? These are all technical aspects that have to be considered also from a more general legal approach. Finally, it's also very important that there are certain comparative methods that they need the cooperation of the importers, or they need the identification of the production cost. And of course, in this case, if you don't have the amounts of cost that were used to produce that kind of goods, because the goods were not introduced by a producer but by a trader, of course, it's very difficult to use those comparative methods. So, yeah, I will move now to what are the national case law. There are several national case laws that have accepted fallback methods based on statistical methodologies or aggregate data. For instance, this was the case in Italy. So Italian authorities can use different methodologies to identify average values that are the Cognos Merce database. That is an IT system that collects information, and on the basis of the information collected in the national database, it is possible to find a certain value of the goods. And the second method is the estimated average values that are extracted by what sometimes they call OLAF numbers, but is basically the JRC Joint Research Center system together with OLAF database that allows to identify these numbers. So Italian case law considers that average values are a reliable tool for detection and verification, but also for evaluation, and of course allows certain benchmarks that are used. Similar situation here in Spain, where the case law has accepted the use of aggregate data, and aggregation data is accepted by the Spanish case law on specific legal arguments, because they are used, for instance, the same country of origin, the same combined nomenclature, the same values of recent transaction, while excluding transaction below a certain amount, so on and so forth. Same system also in Latvia and also in Portugal. Estimated average prices extracted by the JRC OLAF numbers, or reasonable values also in Portugal. The system is fair, well-founded, lawful, therefore is reasonable, and this complies with the EU legislation. So we have seen so far 4 member states where aggregate values have been accepted. Is it the case for all Europe? Well, we have one member state where this was not accepted recently by a tribunal of first instance. During the coffee break, the Belgian colleague explained me that actually this case law is not publicly available. So, however, there have been press articles about this case law, so certain information are now public. I'm not going to make comments on this case. What is public and what I can comment is that the Tribunal of Liège of first instance said that there is an inadequacy of the statistical method for the purpose of establishing the appropriate customs value. Here Belgium is using a system, or at least used in this case, a system that is called the MADB. That is the Market Access Database. That is basically a system that is very similar to the statistical methodologies that have been used by the other member states. That is, this system is based on EU data. It's not national based, as anyway where also EU databases, the one used in Italy, in Latvia and Portugal. The one used in Spain is something that is a bit different as far as I know, because it's more like an aggregate data. It's not a real pure statistical methodology. What can I say here is that the Ecce publication that was published last year after the 4 conferences, the book clearly says that according to the UK case of the Court of Justice, refers to the definition of to the possibility of using statistical values and statistical methodologies in between the member states and the European Commission or the European Union. But it clearly states also that the UK case has not prevented the use of this statistical methodology, or didn't take a position on the use of the statistical methodology between the operator and the customs authorities. Whereas this case law in Belgium has a completely different interpretation. So in my understanding, this tribunal case law is saying something that is contradicted at least by the academia that is attending this conference today here by these 4 universities. Okay, I know that this case will go to appeal, so we'll see then how it will be subsequently decided. Concerning the determination, now I would like to make some general considerations about the national courts. The determination of average values, of course, have been accepted in several member states. They all lead to the determination of the customs value, but of course there is one member state that apparently now is divergent, that, as we have seen, is Belgium, but still is under discussion. Concerning the other aspects of the interpretation of the customs value, I would say that from a fraud perspective, from an OLAF perspective, here we have three different stages that we have absolutely to avoid that leads to the validation of the fraud. The secondary methods allows the identification of an identical similar goods declarations in order to reassess or redetermine the customs value of another declaration that is supposedly undervalued. In order to identify this declaration, it is important that you don't take into consideration necessarily and immediately the lowest value that is on the market. So, for instance, if Mr. De Witt, Professor De Witt sells goods to Mr. Ibanez and this Rolex for 10 euros, and you take in consideration that transaction in order to reassess all the transactions of Rolex, the consequence is the validation of the fraud. So it's not sufficient that because two university professors somewhere in Europe made a transaction from outside the European Union to inside the European Union to take it as a benchmark and to reassess all the transactions of Rolex supposedly undervalued that you had in the European Union. This would be validating the fraud. The lowest identified value in a database is not necessarily fraudulent because I would never imagine even that Professor De Witt and Professor Ibanez are putting in place a fraud. They are just friends. They make a transaction, but you cannot take it as a reference. This is the point. If the number of the customs declarations available for a member state is very big, of course it's probable that the member states will have more chances to find out a very low value to use a benchmark, because bigger is the number, bigger is the chance that there is a very small amount. That's why, in a fraud perspective, what we believe is that it is very important to make a link to the normal market value transaction, to the economic value of the goods. I cannot take into consideration the lowest value ever that I find in the market, but I have to find a normal market value when I identify a benchmark, a customs declaration of identical goods or similar goods, to reassess the customs value. And this is the concept of benchmark. The beauty of this link is that, of course, you respect, in an anti-fraud perspective, the existing legislation, but at the same time, using a strong link with the market value of the goods. And in this way, you avoid to use a wrong or fraudulent value in order to redetermine the goods. Here we link, and also this was, we link all this discussion to a court case that was the Fox case that we also, I think, discussed last year in Rotterdam. That is very important, where the Court of Justice said, okay, but if I, customs operator, already presented the goods at the customs, and those goods were accepted, those declarations were accepted by the customs authorities, you have to take into considerations also in a perspective of a legitimate expectation, perhaps, those goods that were already accepted by me as a customs operator. Well, first of all, the legitimate expectation in customs legislation has to be used as argument very carefully. It's not that we can assume that the legitimate expectations always protects the operators. We can remember, for instance, an important case on legitimate expectation, okay, in a completely different context, the Benster-Boer case in origin frauds. But here, in my opinion, what is important is rather the concept that is linked to values that are accepted. What is the acceptance of the goods by customs authorities? what does the customs authority do when they accept goods by a customs operator? Customs authority, in practical terms, at this point was not analyzed by the Court of Justice, but perhaps for you, members of academia, a reflection on concept of acceptance, perhaps this could be particularly interesting, and perhaps also for the Court of Justice, it would be interesting to further develop or expand on the concept of acceptance. As far as I know, here there is a letter from the customs, Spanish customs, but please correct me if I'm wrong. When goods are accepted, the customs authorities doesn't do nothing. So it means that basically these goods are simply, it doesn't mean that the customs authorities is checking the goods, are opening the goods, are making, no, it means simply that the goods go through the risk analysis system and they pass, so in a way or another. Because unfortunately, as also the Spanish colleague said 2 years ago, here in Valencia, I liked it very much. He said, we don't live in a perfect, ideal world. We live an imperfect world where sometimes even fraudulent goods manage to go through the risk analysis system. So what happens if the customs authorities have accepted goods that are heavily undervalued? Then I have to take into consideration them as a benchmark. No, luckily no, but still, according to this first case, I have to disregard them one by one, like a farmer who has to pull all the weed, the bad weed in his field one by one. But okay, apart from the fact that the farmers luckily today have mechanical tools to pull the weed in the fields, here we believe that in an anti-fraud perspective it is important to disregard everything, maybe just in one shot if it's possible, at customs, even though those customs declarations were previously accepted, and to reassess and push the reassessment and redetermination of the customs value of the goods. So this I'm basically concluding my presentation on the importance of the benchmark and in particular economic value of the imported goods. I think that yes, just in broad terms, the interest of reliable operators is extremely important. It's very important, and of course are not importers who are importing goods for values that are correct, are not losing time in customs or are not undermined by the customs authorities, and that the legitimate trade are not, of course, are not created problems to legitimate trades. But at the same time, the anti-fraud perspective, I think that is still extremely important nowadays for the European Union. So I've concluded. I'm very happy to reply to your questions. Thank you.
Okay, a very interesting presentation. We don't have much time, but I would simply like to say that I see a problem with the view you have expressed, and the European Union is a member of the WTO. We cannot do at home as we see fit or as we see the most appropriate solution, because we have signed an international agreement. And I think that this use of databases, where database is king, is totally incompatible with WTO law. If, say, for example, the United States or China were to challenge the EU at the WTO, I am afraid we would be ashamed, because there are precedents, especially with the Colombia indicative prices case, and I think we are indirectly imposing minimum values. And if they challenge us, I think we would have a negative outcome for the EU. That's the problem, I see. And I think in order to reject the value declared, you need to put something on the table beyond the price is too low. My proposal would be, under the trade facilitation agreement, members of the WTO have promised, if you request the export declaration, the exporting country is under the obligation to provide the export declaration. So my proposal would be a guidance by TAXUD stating, if the value declared is suspiciously low, please request the exporting country the export declaration. They will probably not reply. Okay, if in the period of whatever, 6 months, they do not reply, then yes, reject transaction value. Because then you can claim, it was not my failure, it was the failure of the exporting country not providing the export declaration that triggered the rejection of transaction value. If you do that, in my view, you are complying with the WTO agreement on customs valuation, and you are properly identifying who is failing. The export country is failing because they are not fulfilling their obligation to provide the export declaration. But in the arrangement we have with the Court of Justice of the European Union, the Euro 2000 and the Baltic Master and Focus cases, I think we are right in the substance, but we are in breach of the WTO agreement. In my view, that's a mistake, because we should find a method to properly identify who is failing, which is not the European Union, it is the exporting country and, as you say, fraudulent traders.
Can I reply on this? So,
just briefly.
Yes.
Just briefly.
Please, please. Okay, I'll take all the questions. No problem.
Just briefly, staying on the ECG case law, and the case law is clear. What you said, Diego, is correct. UK case, it doesn't imply that the statistical value cannot be used to do in the relation between trade operators and customs. So the court simply did not say nothing about this. To some extent, I agree with Santiago and with the court. I think we all agree the statistical value cannot be applied by default. By default, cannot be applied. We need to have something more like right to be heard, or to have a bit more a dive into the real situation. What is this more? I don't know, but I think we all agree statistical value cannot be applied by default to all. No, by default to all. But it is legitimate to fight against frauds and so on if we something more than this. And this is clear from my opinion from the ECJ case law. And I add, perhaps in my opinion, it will be also in line with WTO panel. It would be also in line with the WTO panel if we can prove that statistical value is applied with something more than simply apply this.
Other questions? No. Okay. Thank you. I take note of the remarks and also about this possibility to ask this data to China and wait for a certain period, and perhaps this could be a possibility to explore at a legislative stage. Of course, it's not my job, and as Olaf, I don't think that I can make a comment on this possibility or on this idea, but concerning the possibility of using databases, I strongly disagree on the fact that databases are always, from what I understood, totally incompatible with EU legislation. I think that the databases are an important EU tool that help to maintain a strong link with the reality of the transaction. So it is important to find a balance, and in this case I think that we are on the same page, all of us, that is important to find the right balance between fraudulent declarations, fraudulent importers, systematic fraudulent hubs, like the one in the UK, like the others that happened unfortunately in the recent past, are still happening in certain member states, And of course, the other need, that is the one of the legitimate importers.
Okay, and now it's time for Michael Wolfgang from Germany to join us. I see he's
Hello, can you hear me?
Hello, Michael.
Yes, hello, Santiago.
I suppose your weather is not so nice as we are having here in Valencia.
Yeah, that's true, that's true. I'm missing the blue sky.
You look wonderful nevertheless, and we are eager to hear from you.
Thank you very much. So I would like to share my screen. I hope it works. So I hope you can see my slides. So I would like to speak a little bit about the new European Customs Authority, which is proposed by the European Commission in the documents from the May 2023 regarding the customs union reform. And that means that I think several times today was already spoken about the customs reform. Nevertheless, I will give some hints regarding the reform as well in my presentation, but always focused on the new customs authority. And the creation of this authority means that we will have not a single EU customs administration, which was discussed before, but it's because of several reasons not possible from a legal point or maybe practical point of view as well. But it will be and shall be a central EU customs agency. And you know that the European Union the Commission has several customs agencies in place already. And so insofar, this new customs agency shall become a cornerstone of the future EU customs union. Let me just elaborate a little bit about the initiatives which are leading to this new development and to this new proposal. And I quote here the President of the Commission, bring EU customs to the next level. That's the idea of the President of the European Commission. And this is one of the parts of this initiative. But let me just elaborate a little bit about the past, especially the initiatives which have been done by different organizations, institutions, and so on between 2016 and 2022. There is, for example, the Commission Customs Action Plan from 2020 or the Foresight Study, which you maybe remember. The Vice Persons Group report was from 2022, which was discussed in our last project last year as well, or the evaluation of the implementation of the UCC and other initiatives. I don't want to go into details of these initiatives, but I would like to elaborate a little bit about the similarities of the initiatives. And there are more or less 3 or 4 aspects which are more or less similar in all the different proposals, initiatives, and project reports, and so on. And the one is regarding finances and security, which is very much depending on the fight against fraud, and which was discussed this morning several times already. Harmonized sanctions, which was discussed today as well, and establishment of an EU customs authority. These are the points in this regard. Other regard is economy and society. There's also, again, preventing illegal imports, may it be with an impact regarding budget, or may it be with an impact regarding society or other aspects. And now we have also in the world of customs, the green customs, the green policy shall be promoted, and which is, for example, part of CBAM, which was mentioned today as well. or to enforce social standards, for example, in free trade agreements. And then there is one point which is lacking. This is a cooperation between different stakeholders, between the member states, the Commission, between customs and national authorities, and customs and business. So this has to be changed. This has to be strengthened. And how can that be? How can that be possible? Today, every time, always, the digitalization is the solving all the problems. So that's at least the idea of the initiatives and maybe of the policymakers as well. And so far, digitalization, which means that we will have the system harmonization of the IT. And this is part of the topic of customs value and undervaluation and so on, as well as the question of data collection. It's not only maybe for the comparable customs values, but also for other aspects, and especially it's a topic of risk management. And how shall that be done? This is the new reform we have, with 4 goals of the reform package. One of the goals is to reduce administrative burden and simpler procedures, then the creation of a truly single external EU border for import and export of goods, with stronger controls over import and export supply chains. And there will be special customs rules for e-commerce, but I will not elaborate on e-commerce so far. Just only a very brief overview regarding the new customs law we will see. I call it modernized Union Customs Code. I don't know if it will be reformed customs code or what else. This is only my abbreviation I've chosen. There will be the new UCC, so to speak, which is more or less in many articles the same as the current one. Then we will have an import, a regulation regarding e-commerce, and we will have a new point regarding proposal for a council directive regarding import VAT. So these are the 3 new proposals regarding the legislative acts, the drafted legislative acts, which are published in all languages of the member states already, and which are now in the process of discussion and parliamentary activities and European Council and so on. So the core elements of the reform are, and this is the point now for the customs authority, I will speak about, including the new customs data hub. But there are also other core elements like trust and check trader system, the maybe IO plus system, or how it will be called maybe later on, or the topic regarding e-commerce, crisis management system, harmonization of sanctions mentioned today, enhancing cooperation. But I will only speak about the EU Customs Authority and including the EU Customs Data Hub. So please let me, this is again the picture or the graphic of the EU Customs Authority with one single authority in the center of the European Union. In what member state this will be, it's open until now. But it will be a new union body with legal personality. That's according to Article 205 of the new UCC. And maybe it can be called EUCA or OICA or what else. I don't know how it will be named in the future. The core mission of this agency shall, according to Article 207, be to contribute to achieving the mission of customs authorities, to contribute to the operational management of the customs union with coordination and supervision of cooperation between customs authorities and national authorities, and to pool and provide technical expertise to increase efficiency and delivery of results. And of course, this will have impact for customs valuation as well. And I will elaborate about this later on a bit more. And what is one of the other missions is to develop and operate and maintain the IT infrastructure. This is a really big topic in the new Union Code and in the new Union Customs Union of the EU, and to harmonize application and enforcement of customs legislation, which that this is lacking was mentioned today several times, and that it has to be changed. I think we can all agree on this. So regarding the new agency, that will be a single central interface. That's the idea. This new body shall become a single central interface. And it's not only that they have missions or mission, there are some core tasks. And I want to show some of the core tasks to you. For example, that the new agency shall carry out diagnostics and monitor border crossings and checkpoints, for example, that they shall develop common standards and issuing best practice recommendations is one of the points. They shall prepare operational manuals for the practical application of customs procedures. Maybe it's a little bit like the guidance documents today from the Commission. Then they shall carry out performance measurements for the customs union to compare the customs administrations of the member states, for example. And they shall also develop the minimum training content for customs officers. As we all know, the education training of customs officers in the union in the different member states is very different, maybe from learning on the job up to a study program of several years, and that will not be changed with this I think development what is meant with in the Article 208. I think it will be the content, the training content. I don't know if they will also deal with the quantity of hours, for example, which has to be trained. But we will see. And the next point is to promote a recognition system for education and training programs, which we have already in place, as all of you know. The European Union Customs Competency Framework, which is already running and which is still running, and that shall be taken over, I think, by this EU agency when it comes into force. There are more core tasks, for example, the coordination and the support of operational cooperation, which is lacking as the different initiatives found out between customs authorities, for example, or between customs authorities and other authorities at national level. And they shall organize and coordinate joint controls. And one aspect which is, I think, of high importance for the topic of customs valuation as well is that the agency shall assist the Commission in resolving complex classification, valuation, and origin issues. So this is also, I think, to see in connection with the binding evaluation information, which maybe will come before, but we have heard this morning as well, and which is laid down as already existing in the new Union Customs Code, because this is already, I think, given until the new code will come into force. And the agency shall also monitor the decisions taken in this respect and their application. So this is, I think, a very important point for the harmonization of the administering all the different classification, valuation, and origin rules within the European Union. And an additional task is that the agency shall support the Commission and especially in the area of a crisis management mechanism, which is laid down in the new code as well. So what, and from a legal point, interesting is as well, and therefore I have mentioned it here in capital letters, if the customs authority of a member state does not carry out a control recommendation, in that case, the member state must provide the authority with a justification. And that's, I think, a point. We don't have a hierarchy, I think, between the agency and the national administration because of the regulations we have in the Treaty of the Union. And this is a little bit the way into a direction of supervision between the agency and the member states, which is not really laid down in the legal acts here. And it's not, I think, or we can discuss it, how much it is possible according to the Treaty of the European Union between the Commission or the European Union and the member states. So this is a point which is interesting, I think, and which will maybe lead to some different views or maybe to some problems between some member states and customs administrations. But in general, this is already given today as well between the Commission and the member states. So it's only that the task is more or less delegated to this new body. And there are other tasks as well. I would say these tasks are in Article 208 are the main task, which is the main, let's say, mission or as well of the new agency. But they have to administer something as well, and these are the so-called other tasks. That is, they are laid down in Article 209 of the new code, and that means the development, the operation, and maintenance of IT systems, especially the so-called customs data hub. Now that's, I think, is a very important aspect for the agency and for the Commission and for the Customs Union as well. And insofar, I would like to elaborate a little bit on the Customs Data Hub later on. But first, this slide regarding the structure of the new authority. And the structure is we have this EU Customs Authority with staff. I don't know how many people it will be. And the tasks I have already mentioned, but there has to be a structure in it. There has to be a director, there has to be maybe a management board and so on. And the new customs code foresees or provides for the structure that will be a management board steering the authority. And the management board will consist of one person per member state and 2 persons from the Commission. And the management board has to elect a chairperson and a deputy chairperson, and the chairperson has to be from the Commission. That's the structure insofar. The management board has an executive board which is assisting the management boards because of currently maybe 29 people in the management board. It's a lot of, it's like a small parliament already, and therefore to manage the steering there is an executive board which is only consisting of 5 persons from the management board, which is assisting the management board, and I think it will do the daily business insofar in the future. And this management board, or this executive board, consisting of 5 people, the regulation sees for that 2 will come from the commission, so that's the same like in the management board, and 3 from member states. So it's a 5 persons board, which steers together or assist the management board to steer the customs authority. And now let's have a look into the authority. And the authority will be led by an executive director, which will be appointed by the management board. And this person is a temporary agent of the new authority. And this director, maybe a vice and deputy director as well, manages the whole agency. And there's the staff, as I mentioned, consisting of EU servants, but also of seconded national experts. And they will fulfill all the tasks which I have already mentioned before. But now back to the tasks and to the point what the agency has to do in regard of IT. And insofar, the new proposal sees for foresees that there will be a new IT system existing on the level of the European Union. And you see here that there is a center, is the data hub of the European Union, but around are still the IT systems of the member states, which are connected to the IT system of the Union. But not only the member states, the customs administrations of the member states are connected to the data hub, but also other administrations, agencies, or what else, both on the one side of the market surveillance authorities, for example, which are for all the prohibitions and restrictions in charge, which are in connection with the import or export of goods into out of the European Union. This is on the one side. On the other side, we have the law enforcement authorities, which will be connected to this new data hub, so that there is really a transparent system given by this new data collecting institution, or how it will be named. But there are not only the official institutions which have to deal with the data. They need the data from the traders as well. And so, insofar you can see here this picture as well. The traders, they have to deliver all the data regarding a supply chain, and this is really complete from the very first beginning of an export in a third country to via the transport of the goods and to the import into a country, and maybe to the importer as well. So this is the complete supply chain shall be controlled by this customs data hub. All the data shall be delivered by all people involved, all operators involved in the supply chain. And insofar, we can say that this customs data hub that shall become a single data interface for administration and business to have a more transparent supply chain, And to achieve this, all involved parties, all stakeholders have to enter information into this data hub. All third parties, not only the importer, also the ship owner, the forwarder, or other people, other operators involved have to enter information into this system. And this system will be developed by the Commission and implemented and maintained by the Commission. But, as I mentioned before, the Commission will mandate the EU Customs Authority to do so. And insofar, this will be one of the main topics which will be administered by the EU Customs Authority in the future. This will be the big data storage in the European Union, which will come into force maybe in the next years. But I will talk about the time schedule later on as well a little bit. So what is the topic or the question, what is with the IT systems of the member states? Now we have 27 IT systems of the member states, and the final fate of these systems is a little bit unclear, although the EU, the European Union, the Commission has explicitly mentioned in the draft that the goal is to ultimately create a single EU-wide IT system. So that means that the national IT systems will be shut down or what else. I don't know exactly how this will work and if this will become reality, because what I have heard already from some member states is that they have invested so much money in their systems that they think this is lost, and they don't agree to this proposal insofar. But I think from a really risk management point of view, this is not so bad, so to speak. And we will really have, or the Commission and the European Union and the member states, they will really have a better risk analysis on the basis of this data hub. I think this is for sure better, and to fight for the fight against fraud, for example, maybe as well to have more data available regarding transaction value and so on. These data hub will be, I think, positive. Besides the data protection aspects and so, which can be discussed about, but from a real risk analysis, I think this will be will benefit the risk analysis, and the data will be helpful to, for example, in the fight against fraud as well. So at the end, that means that we will have a transparent supply chain, or all supply chains shall become more and more transparent, and the economic operators as well, because the more data are in the customs data hub, the more transparent all the parties involved are, of course. And maybe the idea is behind this customs data hub and the risk analysis, which is possible then maybe with artificial intelligence as well in the near future, that customs knows already today what will be smuggled, or what fraud will be happen tomorrow, so to speak, to foresee all the development and so far. Yes, regarding the timetable, and then I will finish my presentation with this, the timetable of the customs reform. So what we are now in 2023, the proposal for the reform of the customs union has been on the desk, is published. And what happens now? Now happens, of course, the political, according to the European Union Treaty, the process of involving the parliament, the council, and all the other stakeholders, with the discussions with the member states administrations, and maybe also with business representatives from the member states. And this is going on. There was a consultation process already with more than, I think, 180 or so reports or comments and recommendations to this proposal, especially by the business representatives. And what will happen, the idea is that maybe at least or at latest in 2028, the EU Customs Authority will start the activities, especially starting with the EU risk management system, and especially regarding e-commerce. There will become the new e-commerce system, which I don't speak about in my presentation today. And what is for the customs agency, or the authority, which is very important insofar as then the EU Customs Data Hub shall be launched and used initially only for e-commerce, but I think that will change very fast. And the next year, then between 2028 and 2032, the other regulations of the new customs code shall come into force. For example, with the trust and check trader system, the more transparent operator, so to speak, with especially involved in the customs data hub, and has to use the customs data hub to have to enter information into the customs data hub. Interestingly, the customs data hub does not deliver information to the trader. It's only for the risk analysis, for the risk management within the agency or within the commission or within the administration. It's not a mean or a tool for the trader to have a more transparent supply chain. This is another topic, and this is another obligation by the traders themselves. And in 2038, the whole reform package shall be reality, and everything shall run. And there is from the idea of the Commission, there will be no normal AEOs anymore, but only trust and check traders. And the other simplifications will work, and everything shall be in the bright future, so to speak. So this was a very short presentation regarding the customs agency, which will become reality in 2028 latest. When the customs code will enter into force maybe 26 or 27, I don't know. We will see. And then we need the implementation regulation, and the delegated act and so on. I hope it will work until 2028, so that the new customs union at the next level can start. And then we will have a new customs authority, which is a little bit supervising the member states of the European Union, but which will lead, I think, to more harmonization. And that's, from my perspective, necessary for the customs union and helpful as well. Thank you very much so far, and happy to answer any question which might arise. Thank you.
I don't know if there are any questions. It's getting late.
That's always a problem with the last presentation.
No, it's unfortunate to be the last. Thank you, Michael. Very interesting. I don't know. The time schedule is so long that and we don't know what will happen in between. But yes, I agree with you that it would be a positive development to move in that direction. So it's important to stress it. That would be a positive development. So we should try to aim to achieve those goals. Okay, so if no question is raised, I would like to take the opportunity to thank everybody for taking part in this event. I think it has been a very successful opportunity to discuss, to exchange views. There has been a very fluent exchange of opinions, and I think that's good to learn. I learned a lot of things today, for example, regarding the Portuguese arbitration model, which I think is very interesting, and all the presentations were really very suggestive to really reflect about and to improve our knowledge of customs law. Okay, we will continue with this endeavor. The second Ecce project has only started here in Valencia, as the first also started here in Valencia. The project continues, and the next step will be in Rotterdam Erasmus University. We expect by springtime next year we will meet in Rotterdam. So please stay tuned for new events, for new discussions. We will announce the new event on the webpage of the project, the Ecce at the University of Bologna. And we will also announce the event at LinkedIn, as we did with this event. And so we hope we keep meeting with all of you, and we hope to keep discussing these very interesting topics. With this, thank you all for attending, and see you next time in Rotterdam.